Yesterday marked Judge Ketanji Brown Jackson's first day of confirmation hearings before the Senate Judiciary Committee as they consider her nomination to the Supreme Court. While official questioning doesn't begin until today, senators from both sides of the aisle laid the groundwork for what will surely be an intense week of back and forth. Here are a few of the day's standout moments.
It's about your philosophy. Now it's going to be about the historic nature of the pick. And it's going to be about your philosophy. The bottom line here is when it is about philosophy, when it's somebody of color on our side, it's about we're all racist if we ask hard questions. It's not going to fly with us. We're used to it by now, at least I am. So it's not going to matter a bit.
As someone who has deep respect for the adversarial system of justice, I understand the importance of zealous advocacy. But it appears that sometimes this zealous advocacy has gone beyond the pale. And in some instances, it appears that your advocacy has bled over into your decision-making process as a judge.
We are holding a hearing for an accomplished, experienced, highly qualified nominee to the Supreme Court who came to us not through a dark money-funded turnstile, but through a fair and honest selection process.
United States versus Hawkins. This was a child pornography case where the defendant distributed multiple images of child porn, possessed dozens more, including videos. The federal sentencing guidelines recommended a sentence of 97 to 121 months in prison. Prosecutors recommended 24 months in prison. Judge Jackson gave the defendant 3 months in prison. United States versus Chazen. That case, the defendant possessed 48 files of child pornography. The federal guidelines recommended 78 to 97 months in prison. The prosecutor recommended the same. Judge Jackson sentenced him to 28 months.
We've got a lot to dig into. Joining us now to weigh in is political commentator and New York legal aid public defender Olayemi Olurin and policy director at the Conservative Partnership Institute, Rachel Bovard. Welcome to you both.
Morning. Morning.
So, Rachel, let's start with you. I saw that you had written about the claims Josh Hawley was making about the nominee being insufficiently harsh toward sex offenders. So in a recent piece with The Federalist, you argued the Senate should investigate Ketanji Brown Jackson's, quote, leniency towards sex predators. Can you elaborate on that? Because I know Hawley was taking a lot of flack from that, including from some conservatives. Andrew McCarthy of National Review was saying that it was a very disingenuous line of criticism.
Yeah, I disagree pretty strongly with Andy on that point. I don't think it's a disingenuous line of criticism because it speaks to broadly her judicial philosophy. And in the argument that Josh Hawley was making, it wasn't just a simple, one-off, one case, one note that she wrote while at law school. It was a pattern that began when she was in law school, continued through her advocacy on the Sentencing Commission, and then, as her tenure as a judge. And I think there are people that just want to ask questions about this. And I think that's a perfectly acceptable, line of inquiry. This is squarely in the lane of jurisprudential analysis. This goes to, how she may reflect her opinions from the Supreme Court. But I think more than that, it speaks, broadly to, I think, the investigatory work that senators do, right? There's nothing wrong with actually looking into these claims. That is the point of advice and consent, which is the role of the Senate. And moreover, the White House has not been forthcoming with details about her time on the Sentencing Commission. You saw Senator Chuck Grassley, who's the ranking member of the Senate Judiciary Committee, reference the fact that the White House, through the Presidential Records Act or FOIA, is withholding 48,000 pages of documents relating to Judge Jackson's tenure. And so, yeah, I do think that, at the end of the day, they may decide that this is not worth, voting against her or blocking the nomination in some way. But I think it's perfectly acceptable to look into this as a line of inquiry from a Senate confirmation hearing. Well,
it's acceptable to ask questions, obviously, but are those questions valid or correct because I read McCarthy's piece. We've wrote about it as Reason as well. The mandatory minimums are often draconian, and people on both sides of the aisle are okay with taking, some of the lesser sentences because these sentences are crazy. Also, in a lot of the sex offender cases that I've looked at, you have, it's child pornography. If it's 18-year-old has pictures of 17-year-old and they're in some kind of consensual relationship, there's all a significant number of the people on the sex offender registry are actually teenagers. So I think there's a kind of people have this in their imaginations all like 45-year-old creepy dudes or something abusing children. Like half or something people on the sex offender registry, it's non-sexual crimes, things of that nature.
So I think those cases exist. I don't think that's what Josh Hawley, and if you look at the cases he cited, is referring to. In all the cases that we have records for, and again, there's 48,000 pages of documents we don't have. So the ones that we do have, in all the cases we have records for, Judge Jackson went below the maximum, below the minimum, below what the government recommended in all cases but two. And in those two cases, she was statutorily bound at sentencing. And we're dealing with cases, my issue with the McCarthy piece is that he distinguishes and takes great pains to distinguish between production and distribution, as that, these two things are separate. But I think, and in some cases they are, but it glosses over a lot of the details that senators are raising questions about specific to Judge Jackson's sentencing, relating to possessing, in one case, 102 child porn videos, distributing them, including images of the defendant's 10-year-old daughter. Another case involved possession and intent to cross state lines to abuse a 9-year-old. So we're dealing with complicated factors that, I think in the minds of, some senators should reflect heavier sentences. This isn't just a one-off about, consensual adults and having images on their phone. There are much, much more complicated issues at stake here.
And Olayemi, what's your read in general on the idea of whether judges, should be able to go underneath these guidelines given the details of the case, and also how Judge Jackson herself handled these particular ones?
They should. This is a mythical standard. There is nothing in the Constitution that says that a Supreme Court justice needs to be as tough on crime or as punitive as humanly possible. In fact, we should be overjoyed at the idea of a Supreme Court justice that is going to honor and respect people's constitutional rights and try to have compassion for people that stand accused of crimes in our criminal system. We shouldn't want someone that's committed to mass incarceration. Further, I think it's important to say Ketanji Brown Jackson is not just a Black woman. What she is the most qualified person to be nominated to the Supreme Court in recent history, which is a fact known to all, recognized by the American Bar Association, including many of these Republican elected officials that are now pushing back Republican appointed judges. And this is despite these thinly veiled attempts to paint her as this leftist radical. This is a woman that's been endorsed by the largest police union in the country and victim advocacy groups as well. This should be a day we should be excited about the idea that this kind of legitimacy and excellence is reascending to our court.
And Rachel, it feels like some of this from Hawley, at least, is because Hawley plays all of these weird games with the fringe element of the party, and it seems like he's dipping into the weird kind of cult conspiracy stuff around child predation and trying to activate some of that and make it impossible for the Senate to have kind of a reasonable debate around these sentencing guidelines here. So, I mean, are you concerned that element that thinks that there are like cannibals that are running the government are going to get activated by this and see her as like some kind of vanguard for that?
If you're referencing a resurgence of the Pizzagate conspiracy theory, I don't think that's going to happen here. I've watched Josh Hawley for several years now on the Senate Judiciary Committee. You can take issue with how he may do his job in other areas, but I've always thought his line of inquiry has been, fairly mainstream. And he pulled this from her records, the records that we do have. I go back to how, another issue where he questioned a nominee that got a ton of establishment press. Wall Street Journal editorializing against him for questioning Judge Naomi Rao, who was later confirmed to the D.C. Circuit, who he then voted for. But this is kind of what he does. And frankly, in the sense that he questions the nominee, I think legitimately, gets responses to those questions, and then makes an informed choice. I actually think this is what senators are supposed to be doing. There's this, I think, belief that when your side nominates a judge, you're just supposed to rubber stamp them. And that's why Josh Hawley took so much heat for questioning Naomi Rao, because it was a Trump-appointed judge. But that's not the case. You're actually supposed to do an educated line of inquiry. And I think, if you actually read, what Josh Hawley put forward, all of it's from her records. I've seen some commentators try to say, on one hand, well, this is a legitimate debate, among legal scholars about mandatory minimums and sentencing guidelines, but this is also a defamatory smear against Judge Jackson. Well, it can't be both. If you're going to recognize it as a legitimate debate that goes on, you have to also acknowledge that people have different opinions on this and respect them when they do.
Judge Brown Jackson's work as a public defender continues to draw criticism. As we all just heard, Senator John Cornyn accused the judge of allowing her advocacy work to bleed into her court decisions. And last week, Mitch McConnell accused Brown Jackson of a, quote, special empathy for criminals, which Whoopi Goldberg hit back at yesterday on The View. Let's watch.
I also wonder because, Mitch McConnell says her supporters look at her resume and deduce a special empathy for criminals. I know you don't mean this, but that sounds like code.
Yeah. She comes from a law enforcement family.
But it doesn't matter. Listen, she represented a lot of people.
And that's the gig when you're a federal public defender.
That's what you're supposed to do.
I think what you were just hitting on is so important.
It's code, and it's code to tell you that she may be sympathetic to black people.
Yeah.
Olayemi, how would you respond to that? I mean, what's so wrong with having empathy for criminals or for everyone, right? Now, maybe you still have to sentence them harshly, but what's your take?
No, absolutely. Absolutely. That's what it is. It's a dog whistle. That's very clear. And I want to say this. The issue people are having is not that Hawley or any of these Republicans are questioning or, trying to discern anything about this nominee. That's not the issue. The issue is that they're attempting to present the standard as though a judge or a Supreme Court justice is obligated to be harsh on crime or tough on crime or have these pro-punitive belief systems that they're not obligated to have. That's not the constitutional standard, and that's not the standard that everybody is looking to. So I want to say that it's not just that he's questioning her, it's what he's questioning her about and what he's implying. And the implication here is that a Supreme Court justice or someone is supposed to be as punitive as possible, because in all of these cases that he cites, no one walks free. Someone is punished, someone is sentenced, someone is sent to jail for years. The issue is that she's not as severe as she humanly possibly could be. That is the problem. And absolutely, the issue here is not just that, she's sympathetic to criminals. It's the people that stand accused of crimes that are usually poor black and brown people and people that look like her. That's what the issue is, and it's a dog whistle.
And Rachel, what are you hearing from Republicans about how much of a fight they're going to put up here? Because you had Joe Manchin recently take down Sarah Bloom Raskin, the Federal Reserve nominee, but that was at the behest of basically fossil fuel companies. But when it comes to as long as fossil fuel companies and the banks are not interested in an issue, Manchin is pretty reliably Democratic, and I don't see them as particularly invested in this fight, which means that they probably have the 50 votes. So how aggressively are Republicans planning to go after this?
I think Republicans, you heard them, almost to a person yesterday say, we want to have a respectful dialogue with the nominee, and then we're going to vote to, whether or not to confirm her. I don't think this is a situation where they are going to blockade the vote unless something drastically changes between now and when the vote is held. I don't think you're going to see, the tactics that they've used against other nominees, because, there's a difference between, someone serving on the Federal Reserve or someone serving at the Small Business Administration and a Supreme Court justice. But at the same time, you saw Republicans make pains to point out they aren't going to unleash the tactics that Democrats used against Justice Kavanaugh. They don't want to do that. And so I don't think you're going to see, the sort of nastiness that emerged from that debate. But, you will see senators question the nominee. I reject this assumption that, questioning in a certain way is a dog whistle for whatever. These are the advice and consent rule means you look into the nominee's record, temperament, and judicial philosophy, because the highest court in the country, that matters. And so I think that's what they're going to be doing.
Yeah, Olayemi, to Rachel's point, I mean, these have gotten so heated, the Supreme Court nomination proceedings have gotten so heated in recent years. The treatment of Brett Kavanaugh, I think, is something like a lot of people cite on the right, and on the right, running from fervently pro-Trump all the way even to never Trump type people. We're all pretty united in thinking that was just beyond the pale. And so now when they hear that some of the aggressive questioning of Brown Jackson is getting criticized, and maybe it's a little too aggressive, but it seems, well, this is how it goes now.
Well, Brown Jackson isn't accused of sexual assault.
Right. Thank you.
Olayemi, go ahead. What's your take?
I was going to say that. We can't just ignore the part where he was accused of sexual assault and pretty gruesome accusations. That is why he had a tougher confirmation hearing. And we cannot leave that important context out. It's not the same. We're comparing apples and vegetables, and we cannot do that.
And Rachel, actually, how would you compare the accusation of sexual assault confirmation process of Brett Kavanaugh to what we've seen so far with Brown Jackson? Because they tried to go after a little bit of perjury, which I think was legit. He actually did commit perjury. But in general, he was cruising toward confirmation before that happened, right?
Yeah, it was a pretty standard confirmation hearing. If you remember, the completely unfounded allegations of sexual assault were unleashed like the last day of the hearing. And then it just devolved into that. And I do think it's worth pointing out that, he was not at all credibly accused. And then he was on top of that accused of gang rape. He was forced to defend his virginity. He was dismissed for liking beer, for throwing ice. It wasn't just that they tried to derail his confirmation. They tried to ruin his life. And that is what I think a lot of Republicans are responding to say, look, yes, the confirmation process has devolved. I think we can probably all agree on that. The judicial confirmation process is, used to be, you didn't even have to invoke cloture on nominees, right? Like they were just confirmed without a filibuster. We don't exist in that environment anymore. And I think the confirmation of Brett Kavanaugh was the absolute basement gutter of what that has turned into. And I hope we can avoid going back to that ever again.
Olayemi, how much goes back to Mitch McConnell refusing to, meet with Barack Obama's nominee? Do you think that, or does it go all the way back to Bork, or do you think that there was some fundamental break when President Obama was told, no, you actually do not get to name a Supreme Court justice despite what the Constitution says?
Absolutely. I absolutely think that's relevant here. But what I think ultimately what happened in the specific cases of Kavanaugh is that he was accused of a sexual crime. And I want to say this, we've characterized his confirmation hearings as cruel and unfair and they're unfounded. So it sounds to me like we're in agreement that people who stand accused of crimes should be received by people who are going to have compassion and be open to it. That's what it sounds like to me. So I'm very excited about Ketanji Brown Jackson rising to the Supreme Court.
Yeah, particularly those accused of sex offenses.
I think people just accused of something can't just be thrown in jail for forever. I agree with that.
Democrats didn't model that.
Purged from polite society on mere accusation, as the left attempted to do to Kavanaugh.
Found common ground.
Yeah, I guess so. Rachel, Olayemi, thank you so much for joining us.
Thank you.
And coming up, we have a sobering update on the humanitarian crisis in Afghanistan. That's next.